and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Our next item on the agenda is approval of the June 9th minutes. If everyone could take a minute to review the minutes, and the chair will entertain a motion to adopt them.
I move to adopt the minutes.
Is there a second?
Second.
Commissioner Walton moved, Commissioner Flora seconded. Voice vote. All in favor? Aye. Passes with Commissioner Duran absent. Next item on the agenda is item number 7, public comment. Oops, special agenda items, sorry. We have a report.
Yes,
Please.
I have just a couple of things. By now, all tenants and property owners should have received the summer mailing that was sent out with details about the general adjustment, and owners should have received the registration fee bill. If owners have not yet received that, they can call our office and we'll send out a duplicate copy of the bill. The fees have to be paid by August 1st in order for owners to pass through half of the registration fee to the tenants as a surcharge on their monthly rent. And then I wanted to mention Mr. Wessel and his staff held a successful seminar about calculating the annual rent increase earlier this month. We had a number of attendees who felt that it was very helpful in accurately preparing the rent increase notices. And finally, I wanted to mention, back in April, we had a property owner come and speak with us about his interest in converting his building to solar power. And so we've talked, we met with him after that meeting, and then we met with the Office of Sustainability. And it turns out that they have a program where they're looking to identify some multifamily properties that might be interested in doing this type of conversion. So we've asked them to come and talk with the board or make a little presentation to the board about the program and about kind of the basics of solar energy. So they will be coming to the August meeting. We have a fairly light agenda, so they will join us then. So that's what I have this evening. Oh, I did want to mention about tonight's agenda. The board knows, but for the public, we've had a number of our appeals. 2 of them were withdrawn, the case at 827 20th Street, Unit B, and also the case at 2317 Ocean Park, Unit A. Those were both withdrawn. And the case at 422 Ashland Avenue, Unit A, was continued to September 8th. But we will have the other appeal case this evening. And that's all I have.
Okay. Next item on the agenda is item number 7, public comment. Request from the members of public to speak to the board on any issue of general interest to the community that is within the board's subject matter jurisdiction. State law prohibits the board from taking any action on items not listed on the agenda. Looks like we have several speakers. We do have one speaker who is not designated an agenda item. Miss. They're both for public comment. Okay. So we'll start with Mr. Bob Karp, please. And you'll have 3 minutes. And then Miss.
This is my wife, Susan Karp.
Hi, Susan. Are
Hi.
you donating your time or are you also speaking?
We'll take our 6 minutes together.
Okay,
That's
great.
Okay.
Thank you.
Thank you.
As you mentioned, I'm Bob Karp, and this is my wife, Susan. We met here as renters in Santa Monica in the same building. Later on, as we fast forward, we bought a home here for a number of years. Our family started to grow. We live in Pacific Palisades, sort of next door right now. When I concluded my roofing career, one of my prized possessions was the property that the business was founded on, and I exchanged that for a 4-unit building here in Santa Monica. That was in 2013.
We have a big debt on it too, though.
We have a debt, but we service our debt. We take care of our licensing. We do whatever it takes as owners to run the place, and we make improvements. Anyway, our issue for tonight is that we have a house and a triplex on the same property. The house is right on Centinela in Nebraska. We have 3 tenants, one of which just recently moved. We were informed by Joe at Rent Control that the other two tenants were allowed to bring another roommate in
For the third bedroom in that
for,
house, yes.
for the third bedroom, right? And that was okay with us until we found out by seeing a sign on our property, West Side Rentals, that the two tenants were going to the open market to get the highest amount they could possibly get for the room that was vacated. This struck Susan and I as very wrong. We worked very hard to become the owners. I have 35 years of sweat equity in that building, and I don't understand how, I understand the part about needing to avoid hardship, but we had three tenants all equally paying the same amount. It was $2,500 rent, about $835 each, and we find Westside Rental posting for $1,500 for a roommate. Now, as it turned out, due to the open market, they found someone for $1,350. And so we've done a background check through our management company. They're okayed, and they're now able to move in. But what sticks in our throat is, how did these two tenants manage to profit off of my property?
It is a rent-controlled property. It shouldn't, we aren't allowed to take excess profit and have
Our
it-
increase, as you mentioned, came to us recently, and we were given $25 for the entire house. These two tenants are letting out a room for $1,350, which is almost $600 more than the previous person paid. So that difference is going into their pockets. They're profiting on my property, and I want to know how I can address you folks to help straighten that out.
We also see this
Or
as
hear your comments, please.
Yes, we see this as a problem over time too. These tenants are unregulated as far as what they do with their subtenant now. They can raise anytime they want, or they can get someone else. One of them can leave, and the third one can live rent free there with two other tenants, or even one other tenant in the future. And
What happens in this unit can easily happen in any of the other units where there can be a vacancy of one person. And it seems like what this creates is a vested interest in whoever remains and is profiting to just stay there. It's a little business within my business. And I would like to see that anybody stay the full term of what they want to stay, but not for that reason. Not because they don't want to give up their profit that they're making by renting out my property.
These tenants, they're young professionals. I believe they were all in college when they started to rent here, and they're doing really well. But this kind of practice that they're learning to get into, it appears to me to be a form of embezzlement. It's just unethical. It's not right for them to
Whatever
be
you want to
learning.
call it, it's not right.
No.
They're not learning the right way to go about earning a living. This is not how you earn a living. So we need some help, please. So if you could help us.
This can happen all over Santa Monica. It will, once the word gets out. The rents are escalating so fast everywhere, except in the rent-controlled properties, that it's gonna be a big deal.
Yeah, it might have been different years ago. Rents didn't go up so fast, but we've seen some amazing things with rents.
Just in the last 3 years that we've had the property, they've gone up quite a bit.
So, thank you, Mr. and Mrs. Karp. Just to be clear for all the board members, this is a time where board members can't take action on any item. But I think what may be, and I want to remind my colleagues that we have to kind of refrain from deliberating on this item. What I would suggest is maybe, and I'll turn this over to either Stephen or Tracy, who may be able to give you some direction on this situation.
Yes.
But after this meeting, I would encourage you also to follow up with the staff in our office who should be able to assist you. So Stephen or Tracy, who should I? Okay.
Well, I spoke with Mr. and Mrs. Karp before the meeting started, and under the rent control law, the maximum allowable rent has been established for the house. So it's correct that they cannot collect more than the maximum allowable rent, but it's my understanding that within the lease, there's nothing that says that the amount of rent for each of the bedrooms needs to be apportioned equally. If there were such a thing, then of course the current tenants could not look for a roommate who's going to pay more than they're paying. It would also certainly be unlawful for the current tenants to attempt to collect more than the maximum allowable rent on the unit.
But they're not regulated, so how would anyone know?
Well, altogether, they're going to pay the maximum allowable rent. And we don't know whether there was an agreement among them with respect to a preferred bedroom or parking space, although I understand that's not the case here. But there's no violation in the rent control law for what's going on right now. And I don't know if Mr. Lewis would like to add to that.
No.
Well, I would like to add, if I might.
Uh,
It's just, no matter how you slice it, the tenants are making a profit, and I don't think that that's right. It may be justified under the current law, so maybe what I'm asking is, how do we change that? How could it be done more fairly, so that, again, I don't have to watch 1, 2, 3, maybe all 4 of my units start to be sublet, in essence, by the existing tenants, and I have to hold the empty bag, you know.
And all the work.
And I still, right, we still pay all the bills, we still are accountable, well, I have the liability and the insurances, we do everything. So
We pay the income taxes, they're gonna get out,
So,
with, no income tax.
the best I can see here is that somebody comes in like for like, and so that there is no hardship on them. But if there's gonna be a profit, then I would say that profit should come here, and the tenants will have put aside their hardship issue, even though the rent may be higher.
Commissioner Walton, and then I'm going to close it out.
I just want to clarify what your dispute or complaint is. You don't like the way that the tenants are apportioning the rent amongst themselves. Is that correct?
No, not exactly. It is not an apportionment of rent amongst themselves, because they are bringing in a new party, and that party is not given the opportunity to negotiate the rents between them.
How do you know that?
Because
it's,
they're advertising on West Side Rentals the amount that they're looking for.
But you weren't present at the meeting or the negotiations.
No,
no,
Right, so essentially, there's 3 tenants living in your property,
yes,
and they have reached an agreement about how much each of them are going to pay.
we don't know that. We don't know if the new tenant knows
Okay,
what
but I
the
mean,
other two
if
are
they-
paying.
Commissioner Walton, I just want to, this
Yeah,
is
I'm just
really
going to ask
supposed
my
to be.
questions in the way that I want to.
Okay,
Thank
but
you.
you're out of order.
Then
You're
I'm out of order.
You're out of order,
Yeah.
and this is not the time for public debate, so I'm going to ask you to please yield the floor.
I'm not going to yield.
Then you're-
I'm going to
you're
ask
out of
my
order.
question. Okay. So the 3 people are paying the maximum allowable rent.
yes.
And the other thing that I want to understand is, how are they profiting by that?
The 2 existing tenants,
The original
the
leaseholders.
original all 3 tenants paid equally. So the amount they paid was approximately $835 each. Now they're receiving the rent from the party that they brought in through the open market, and they obviously will benefit from that amount, whether they use it, quote unquote, to reduce their rent or to lease a car or whatever they want to do. It's extra money in their pockets. That's what I don't like.
Thank
And
you.
under rent control, I thought it was all about being fair to everybody. I don't see how this person moving in is being treated fairly. I don't see how I'm being treated fairly.
I think I understand your position.
Thank you.
Thank you.
Okay,
Thank you.
thank you very much. And so we might be able to speak to somebody afterwards?
I would encourage you to please speak to our rent control staff and follow up with any of us directly. We're all available through our santamonica.gov emails, so smgov.net. And I think staff could provide you with those emails as well. We
Where's
certainly
staff
want to
located?
understand.
Excuse me?
So this is our executive director, Tracy
okay,
Condon.
Tracy.
This is our general counsel, Stephen Lewis, and his staff members. So there are people here who are available to help you, and I could
I think
could
what
go
I
around
meant
the
is,
room.
if we stay tonight, can we speak to somebody tonight, or should we do this at a different time?
I think you could speak to someone after the meeting, but I would also encourage you to come during business hours so that we could have a full
Maybe that's better.
conversation.
Yes,
Okay.
okay.
You know,
Thank you all very
I
much.
want to mention too, I don't think we're going to be able to live with this situation very long. It really irks us that these kids are being trained in this way, and it's our responsibility. It's we're part of this. It just irks us.
And it does
We'll-
seem
we'll
like
see.
you are really very sympathetic landlords, and I think, this is not the appropriate forum for us to deliberate on this under the Brown Act, which is why we're being so circumspect in what we
Right.
can say. We're really trying to be respectful of the public hearing.
Well, we just don't know where to go.
We encourage you to follow up with us offline, and if there's anything we can do, I personally, certainly want to understand the situation better.
Thank
Okay,
you for
good.
so much
Yes,
time. Really
thanks.
appreciate it. All right.
Okay, next item on the agenda is 10A1, 1722, owner occupancy exemption, 548 11th Street. May we have a staff report, please?
Yes, good evening, Commissioners. Oh, I'm so sorry. No, I'm not. But good evening anyway.
Commissioners, our first exemption tonight, as you mentioned, 548 11th Street. The applicants are Lisa Kanoff and Mark Kaiserman. Ms. Kanoff and Mr. Kaiserman bought this property on August 11th, 1994, and they state that they moved on to the property at that time. They have applied for its exemption as an owner-occupied property of 3 units or less. They are the property's sole owners. The property meets the unit limit for the exemption, and so the only question before you is whether they've shown that they've lived on the property as a principal residence since at least December 21st, 2015, which is 120 days prior to the filing of their exemption. They submitted utility records, financial statements, and government records that show they have used the property as their mailing address during that period. They don't own any other property in LA County. The voter registrar and DMV records show the property as their mailing address. There were no tenants in the property who could provide evidence as to their residency from a third party, so we sent our board investigator to conduct a site visit, and he reported that the unit was fully furnished with personal possessions and a fully stocked kitchen and bathroom, consistent with their claimed occupancy. And for that reason, because the preponderance of the evidence shows that they have met the requirements for the exemption, staff recommends the board grant this application and adopt the attached findings of fact and conclusions of law.
Is there any commissioner discussion? Commissioner Flora?
Would the chair entertain the idea of considering these 3 items relatively consent calendar, barring a commissioner perhaps raising their hand and saying they have an issue on items 1, 2, or 3? Because I certainly would propose that we follow the staff recommendation and grant an approval for all 3, unless you really wanted to go through and discuss them. These are the first things I read when we get our packet.
Yeah.
So they seem pretty cut and dry to me if we want to expedite, but
Sure.
I don't know how the chair would like to go
Is there-
with these tonight.
Is there any objection to granting the jurisdictional items by consent? Do we need a voice vote or a roll call vote? Okay, so do we need a motion? Okay, Chair will entertain a motion to grant the jurisdictional items A1 through 3 by consent. Is there a second?
Second.
Okay, Commissioner Walton seconded. Roll call vote, please.
Commissioner Duran,
Yes.
Commissioner Flora,
Yes.
Commissioner Walton,
Yes.
Commissioner Foster,
Yes.
and Commissioner Phillips.
Yes.
Motion carries.
Next item on the agenda is 10B4. M-0921, 1915 Ocean Avenue, Unit 211. Appellant ASN. May we have a staff report, please?
Yes, and now good evening for real. Last year's general adjustment for controlled units was less than 0.5%. Susan Lucca's landlord increased her rent by closer to 30%. She paid the increase and filed a petition for reimbursement, arguing that the increase wasn't in excess of what the rent control law allowed. Her landlord, ASN Santa Monica, argues that the rent control law simply doesn't apply here because, according to ASN, the board granted the unit a permanent exemption from rent control in 1994. In fact, the board has never granted any form of exemption for the unit and never had the legal authority to do so. But it did in 1994 grant what is sometimes referred to as a removal permit for the unit. These two things, an exemption and a removal permit, are not the same. To understand why, we must look to the city charter, which is the sole source of the board's authority and which tells us what removal permits and exemptions are. The charter begins with the principle that every rental unit in the city is subject to rent control, and I've put up on the screens here a few visual aids as we go through this. Under Charter Section 1801C, the term controlled rental units refers to all residential rental units in the city of Santa Monica, except those that fit within certain categories, like motel, hotel, boarding house rooms, units in hospitals, convents, monasteries, or other nonprofit institutions, government-owned or operated units if exempt under state or federal law, units in owner-occupied properties with 3 or fewer units, which the board just dealt with a minute ago, new construction, child care or other nonprofit residential social service rooms, or certain single-family homes. Susan Lalka's unit, a regular apartment in a 70-unit building, satisfies none of these criteria. It is therefore not exempt from rent control under the charter's plain language. Nor does ASN argue that the unit does satisfy any of these exemption criteria. The basis for its claim that the unit is exempt is that in 1994, the board granted a so-called removal permit. ASN argues that this was, pure and simple, a permit to remove the unit from rent control regulation, effectively declaring the unit exempt, even though the charter specifically says that all rental units are controlled unless they meet certain criteria, which this unit doesn't meet. There are two problems with this argument. First, the board has no authority to simply declare a unit exempt. At most, it can find that a unit is exempt because it meets narrow exemption criteria specified in the charter, which again, this unit does not. But the second problem is that the charter tells us what a removal permit is, and it is not permission to continue renting a unit free from the law that applies to everyone else. It is permission to take a unit out from under rent control regulation by ceasing to engage in the regulated activity of renting it. And this is clear from the charter's plain language, which exists in Charter Section 1803T, which says that a removal permit is permission granted by the board to remove a controlled rental unit from the rental housing market by demolition, conversion, or any other means. In order to be allowed to take a unit off the rental housing market by demolition, conversion, or other means, an owner must show that the unit can't generate a fair return. That also is included in Section 1803T. In the 1980s, the board enacted regulations governing removals and concluded that a landlord couldn't make a fair return on a unit if the market rate for that unit was even lower than the controlled amount. If the owner could make that showing, it could apply for a removal permit under Regulation 5012A. And here's the language of 5012A. This is the exact language, but this is what it says in substance. The board may issue a permit, the first part of it is exactly the language. The board may issue a permit to remove a controlled rental unit from the rental housing market if it finds that the landlord is unable to collect the unit's MAR. It spells out maximum allowable rent in the actual regulation. ASN's predecessor applied for a permit under that regulation seeking to remove the unit where Ms. Lalka now lives from the rental housing market. Because it couldn't collect even the unit's MAR, and the board received this application. It's a little bit small here, but if you squint a bit, you can see in the first paragraph, application is hereby made for a permit to remove a controlled rental unit from the residential rental market pursuant to the city charter. It did so under the regulation that I just referred to, saying that they couldn't collect the maximum allowable rent, meaning that they couldn't achieve a fair return. The board agreed that this was true and granted the removal permit. So to recap, ASN's predecessor applied for permission to remove a unit from the rental housing market. It did so under Regulation 5012A, which governed applications to remove units from the rental housing market. And that regulation was authorized under Charter Section 1803T, which allows landlords to apply to remove units from the rental housing market. But the unit either never was removed from the rental housing market or has been returned to it because it is now indisputably on the rental housing market. It's being rented at market rate to Ms. Lalka. It is a rental unit in the city of Santa Monica. It satisfies none of the categories that under the charter would make it exempt. It is a controlled, currently rented rental unit. Nonetheless, staff incorrectly told both ASN and its predecessors that the unit was exempt. Staff apparently understood that by granting permission to remove the unit from the rental housing market, the board was really granting permission to keep the unit on the rental housing market, but with the benefit of being exempt from rent control, even though the unit satisfies no exemption criteria. Staff apparently had this understanding even though the board does not have and has never had the legal authority to do anything that differs from what the charter actually says. But there is no question that staff did in fact have this incorrect understanding and conveyed it to ASN and its predecessors. So when ASN increased Ms. Lalka's rent by 30%, it thought that it had the right to do so. That's why the hearing examiner, although finding that the increase was illegal, imposed no penalty. But the hearing examiner correctly concluded that regardless of what staff might have said or thought in the past, the law must be correctly applied. And under the law, Ms. Lalka's apartment is a controlled rental unit. Because ASN collected more from Lalka than the law allows, it must return to her the excess that it collected. In its appeal, ASN principally argues that regardless of what the city charter says, Ms. Lalka's unit either is exempt from rent control or even if it is not exempt, should be treated as such. First, it argues that the unit must be exempt because the board never issued a formal decision terminating its exemption. But again, the unit never was exempt, so there was no exemption under any law for the board to terminate. At no point does ASN offer any evidence or argument to the contrary. Instead, it makes irrelevant arguments about the standard of proof of facts, equally irrelevant arguments about when a landlord's right to remove a unit from the rental housing market terminates, and a somewhat nonsensical argument about ex post facto laws which apply only to criminal laws and laws impairing contracts when there is no contract at issue here. ASN next argues that the 1994 board could not have understood that its predecessor intended to follow through with its stated intention to remove the unit from the rental housing market or exercise its right under the city charter by actually doing so because the board didn't require evidence about how the unit would be used after it ceased to be rented. But because the board regulates only rental units, what became of the unit after it ceased to be rented was none of the board's concern at the time. It was therefore totally rational that it would not inquire what the use of it was going to be afterwards. Also, as part of this argument, ASN notes that the charter said in 1994, just as it does now, that an owner may apply to remove a controlled unit from the rental housing market by demolition, conversion, or any other means. It asserts that this phrase, by any other means, is, quote, a broad category that would encompass removal from regulation, unquote, while a unit continues to be kept on the rental housing market. But ASN makes no effort to explain how the phrase by any other means is so elastic that it can be stretched back to entirely efface the phrase removal from the rental housing market that precedes it. Again, the charter allows a unit to be removed from the rental housing market by other means, but it still must be removed from the rental housing market. And this unit either never was removed or was removed but was then later returned. Either way, it is now a rental housing unit, and as a rental housing unit that is on the rental housing market that satisfies no exemption criteria, it's subject to rent control. This brings us to what appears to be ASN's primary argument, that whatever the law may actually be, staff told it that the unit was exempt. And because staff made that mistake, the mistake should now be adopted by the board and should be given the force of law, even if it would mean depriving Ms. Lalka of rights that the law unequivocally guarantees her. Even in the absence of relevant law, it should be clear that a mistake, once having been made, need not be repeated and carried on eternally. But in this case, we have more than mere common sense to rely on because the courts have unanimously and repeatedly made clear that a government body's highest responsibility is to the faithful and correct application of the laws with whose administration it's charged. In this case, the law requires that the board recognize Ms. Lalka's unit as controlled. It cannot deprive her of the rights that the law guarantees her merely for the sake of perpetuating a mistake that the staff, not even the board itself, long ago committed, however unfortunate that mistake may have been. So staff recommends that the hearing examiner's decision concluding that Ms. Lalka's unit is subject to rent control be affirmed in its entirety. Thank you.
Thank you. We have two speakers on this item. First is Miss Linda Hollenbeck, and you will be speaking for the appellant. You have 5 minutes.
Commissioner Phyllis, I just want to let you know that the timer is not working at the speaker podium, so with a minute to go, I'll warn you that there's a minute to go.
Thank you. First, this property is and has been exempt from regulation. My client is not engaged in trickery. The board in 1994, in fact, exactly 22 years ago today, did in fact grant permanent exemption from rent control regulation. The form used up there and shown to you by Mr. Lewis was a pre-printed form. The language pre-printed did not reflect what the application was actually about. It was simply the only form available, and that is why the language is there. It was not put in there by anybody. The agenda did in fact, the agenda for that evening did in fact reflect the intent of the city when it stated that the agenda item was for removal from regulation. It did not say it was for removal from rental housing use. It said removal from regulation because that is what the board intended and that is what Mr. Lambert, the owner at the time, intended. This should not be a game played out with a war of words, taking bits and pieces of forms and regulations and presented in a manner to best make up a specific position. As in life, that does not make it so. Today I was able to review the video from that evening. I would play it for you, but it would use up my talking time, so I'm not going to, but I will put it into evidence. Not once at the hearing was it mentioned that this agenda item was for permanent removal from rental housing use. With that said, my client, the management and the owner of this property, strives to follow the law and do right by their tenants. They are here tonight because they believe strongly that their position is correct. It was an exception. It was a loophole. This loophole was closed and the law removed from the books. I believe so that no one else could take advantage of that legal loophole, but at the time it was legal. The claim is that the board did not have the authority to make the decision to exempt these units. I think the board did have the authority, and they did the right thing, which was backed up by the action of the city for the next 20 plus years. I know that when I need information about Santa Monica rent control, I've always been able to call the city and get an answer. I've always relied upon those answers, and I'm very disturbed that I am now being told that consistent advice that has been given for 20 years cannot be relied upon to the detriment of my client. Exhibit 28, the agenda for July 14th, 1994, application seeking removal of units for regulation pursuant to Category A. Again, that's what it was about, removal from regulation. Pursuant to Category A. What they did, what was used, was Category A parameters was used, and that meant that they could not rent out the units for the maximum allowable rent. They were not able to find a tenant. They followed all of the parameters, they passed that test, and they were granted the exemption. Because there was not a specific regulation at that time, this was what was being done, this was the regulation, this was what they were granting. This is what was done. There is no mistake. The staff was unaware of any evidence which can rebut the presumption that the landlord was unable to collect the current MAR for the units in question. Therefore, they granted the application for removal from regulation. The findings by the board, there was a big mistake in the decision of the hearing officer. Mr. Lambert, who was the owner at the time, who appeared at the hearing, never attempted to remove the subject units from rental housing use. He always and only filed his application to remove the units from the rent control regulation as stated in the agenda. He never attempted to and never did demolish or convert. These units were 3 in a 70-unit building. They were not uninhabitable. They were always rented when there was a paying tenant available. There was no cover-up. There was no attempt to hide the units, to hide that the units were rented. They were exempt permanently using the parameters of Category A. This was an exception that was later closed. On page 7 of the decision, units will lose their exempt status when the use that qualified the unit for exemption ceases to exist. Here, the use was exemption from regulation for units that would be rented. The use was never no use at all. The city has a shortage. They would never consider taking perfectly good units off of the rental housing market. They were attempting to assist Mr. Lambert in renting his units for a lower rent without the penalty of permanently lowering the MAR.
1 minute.
So that he could not raise the rent to a decent level when market factors changed. By removing these units from regulation, the city was allowing Mr. Lambert to continue to rent his units without a permanent penalty. The authority of the board, page 9, paragraph 1. The decision attempts to state that the board did not have the authority to exempt those units. If that is the case, then the board has no authority to now reverse that decision. It can't be both ways. If they had the authority, then the units continue with the permanent exemption they were granted in 1994. The city's database had the units coded as exempt. This was not a mistake. It was an accurate depiction of the status of the 3 units, permanently exempt. Page 18, paragraph 1. The board repealed Regulation 5014 after it determined that it did not require the board to find that the landlord could not make a fair return. In fact, the board repealed the regulation so that no one else could take advantage of the exceptions that Mr. Lambert legally took advantage of. Page 19, paragraph 24. Permanent removal would confer a benefit on respondent to which it is not entitled under the rent control law. It was entitled to it at that time it was granted under the rent control law that was in effect at that time. Even if the board affirms their decision, there should be no excess rent returned to tenant. At the time the rent was collected, the units were deemed exempt by both the city and the owner. The only person that really knows what happened is Mr. Lambert, nobody else. Nobody here was there. Nobody else knows.
Our next speaker is Judy Dart. Ms. Dart, you'll have 3 minutes.
Thank you. I am appearing on behalf of my daughter, Susan Lauka, who's the tenant. I am licensed to practice law in Michigan, but not in California. I read with great interest the memos that were produced by Stephen Lewis and listened to his argument today. I also attended the hearings, there were 2, and I read all of the submissions that the appellant's lawyer put in. There was nothing that was submitted that would controvert anything Stephen Lewis said. I think the statute is very clear that it was only, the removal permit was only permitted to remove the unit from the rental housing market. The application clearly says that is an application to remove the unit from the rental housing market. And I don't understand how the board has the authority to do anything that it is not permitted by law to do. And secondly, I think with respect to estoppel, the argument is in favor of my daughter, Susan. She's paying almost 30% higher rent than she did the first year. And it is an extreme hardship for her to pay that rent. And I think that the rent control law was designed to help people be able to find affordable housing. And that's all I have to say, unless any of you have any questions.
Thank you. Move now into commissioner discussion. Commissioner Foster.
Unless no one jumped at the queue there, I'm prepared to make a motion to affirm the hearing examiner's decision and deny ASN's appeal.
I'll second that motion.
Any discussion? Okay, move to a roll call vote.
Commissioner Flora,
Yes.
Commissioner Walton,
Yes.
Commissioner Foster,
Yes.
Commissioner Duran,
Yes.
Commissioner Phyllis.
Yes.
Motion carries.
Thank you. I actually have one clarification just for the record. And I think this was what was said in the motion, but for the reasons stated, I just want to make sure that we have a clear record. We're affirming the hearing officer's decision for the reasons stated in the staff report.
I rephrased that.
Okay, is that,
Yeah, that's why I was saying yes too.
Yes.
Anyway.
is that, can we just have another roll call just to make sure that it's very clear? So for the reasons stated in the staff report, that's a friendly amendment to Commissioner Foster's motion and Commissioner Walton's second.
Okay.
We're affirming the hearing officer's decision.
Commissioner Flora,
Yes.
Commissioner Walton,
Aye.
Commissioner Duran,
Yes.
Commissioner Foster,
Yes.
and Commissioner Phyllis.
Yes.
Motion carries.
Okay, next item on the agenda is 12A, a resolution of the Rent Control Board of the City of Santa Monica urging the City Council to determine whether there are identifiable factors that increase the likelihood that a rent-controlled property will be removed from the rental housing market. I think since this was an item that I had originally requested, I'll give a brief overview. I'm trying to find the resolution in our packet. Okay, so I had requested that we put this item on the agenda last month because Santa Monica seems to be in a state of flux right now, in terms of, new opportunities for planning with the downtown community plan. There are also additional considerations for planning in the Pico neighborhood, planning and zoning. We know that there is an initiative coming up on the November ballot, which could potentially implicate zoning considerations with, it's the Land Use Voter Empowerment Initiative, or the LOVE Initiative. And there's been a lot of talk in the community about the impacts that zoning and other factors could potentially have on Ellis activity. And so I had talked with staff quite a bit about opportunities for us to better educate ourselves on what may predict Ellis activity, and ways that we might encourage landlords or support landlords to maintain their rent-controlled housing stock. So really, this is, I think, educational in many respects, and truly geared toward the preservation of rent-controlled housing stock and our support as a community of landlords who choose to do so. So given that this has zoning implications, which fall within the jurisdiction of City Council, it seemed to me that the most logical body to undertake such a study would be City Council. So with this resolution, which should be available in everyone's packet, it's Resolution 16-002, which I don't think we need to read unless someone prefers it to be read for the record, that we request that City Council undertake such a study. And I think hopefully it will fill some gaps in our understanding of Ellising. Commissioner Flora.
Yeah, first of all, I want to thank the chair for her leadership on this. That we are in the era of big data and analytics, and I think it never hurts when one has more information. It only hurts when we have less. And I think if we can, I remember in statistics that we always did the cross tabs. Well, if we do whatever the kids today are calling the cross tabs, and we find some links, that there are some motivating factors or economic factors or whatnot that even in one part of town may be affecting a property owner's decision over another part of town. I think it just might be good for the public to know what these factors might be. Mm-hmm. Now, obviously, we have to be careful. We can't be in the business of persuading landlords to not do this or that with their property with regard to their right to go out of the rental business. But if we find through this that maybe there could be some assistance or office advice, things that are helpful, if they have certain information that is brought about by this study, it might be helpful. I think everybody wins with more information. Nobody wins without the information. So I'm certainly going to vote to pass this along for the City Council to consider asking their granted very busy staff. But hopefully they'll see the wisdom in trying to get ahead of this as well. So thank you again for bringing it forward.
Thank you, Commissioner Flora. And I realized I hadn't given, I think, a full overview of some of the possible predictors that I think might be related to LX activity or may fall within the scope of the study. And I think it is listed in the resolution. But just, these things could include anything from land values, rates of appreciation, zoning, neighborhood, building size, changes in ownership, the ratio of market to long-term rentals. These are all things that are very much kind of in the vocabulary of our city, especially right now in an election year with a land use initiative on the ballot. So it's our hope, I think certainly my hope, that such a study would help educate both the members of the public and the people making the decisions on zoning, to enact measures that help encourage the preservation of rent control. And I do want to make abundantly clear, both for our members of the public and for the audience, that it was certainly not my intention in bringing this to the board to impede anyway Ellis activity. Of course, that is not the purpose of this resolution. The purpose of this resolution is to understand, and that understanding will hopefully facilitate ways in which we can support our landlords in preserving rent-controlled housing stock. Okay, Commissioner Drawn.
Thank you, Madam Chair. I am strongly in favor of more information. I guess it's a truism, right? More information leads to better decisions. So whatever the results of this study, should the City Council decide to pursue it, which I hope that they will, I think will send us down the road more enlightened on the effects, the causes, the benefits, the downsides of the Ellis Act. So whatever results this study should bring, I think would be valuable information, and I will definitely support this resolution.
Chair will entertain a motion to adopt the resolution.
I'll let Steve do it because he was late.
My apologies.
Not to bring that up. We all were. That's the joke. That's really the joke.
Excuse me.
Except for Commissioner Walden.
Except for Steve. Except for Christopher. The one who lives the closest.
Walking distance.
I would like to move that we adopt Resolution 16-002 and that we forward it along to the City Council and its staff to direct appropriate staff to research and analyze which factors, if any, make Ellis withdrawals more likely. Such factors might include land values, rates of appreciation, zoning, neighborhood, building size, changes in ownership, the ratio of market to long-term rentals, and any other factors that the city's professional staff might deem relevant. The board will be happy to provide any information in its possession or control that will facilitate this research and analysis.
El Segundo.
Okay, Commissioner Drawn moved. Commissioner Walton seconded. May we have a roll call vote, please?
Commissioner Foster,
Yes.
Commissioner Duran,
Yes.
Commissioner Flora,
Yes.
Commissioner Walton,
Yes.
and Commissioner Phyllis.
Yes.
Motion carries.
Okay. Before we adjourn, I would just like to say a few words to honor the people who have been affected by the tragedy in Nice. I think the news has hit swiftly and deeply, especially in my heart, on Bastille Day, and I would ask that we adjourn in their honor and memory. Is there a motion to adjourn?
So moved.
Commissioner Walton moves. There's
Second.
Commissioner Flores seconds. Voice vote, please. Voice? Okay. All right. We are adjourned. All in favor? Aye.